All right, welcome back, everyone. If you've continued to follow the series, we're on number 3 of our license law and review comments section, also known as the somewhat cliff notes of Appendix A. So can again consider Appendix A, that section of your textbook, to go along with the license law and rule comments. That's what we're breaking down in this series. And again, we're on video number 3. Now, we just came from video number 2, where we continue to talk about the broker statuses or categories, remembering that there's one license in North Carolina, that's the broker's license, but it can have multiple categories or statuses, what each of those statuses means, or further defining again each of those statuses, including the broker in charge status. We also talked a lot about trust accounts. We kind of sidebarred there after talking about the broker in charge status, because trust accounts are one of those things that are a big responsibility, to say the least, especially for BICs who hold trust accounts. Then we continued on with licensing of business entities. So again, forming a LLC with the Secretary of State, and then taking that further and getting a firm license. So we covered that. We also talked about why June is so important, given the dates that are involved in June. Remember, your renewal date is in June, and also your continuing education deadline is every June 10th specifically, and again, your renewal being June 30th. And then we concluded video number 2 with a little bit more about the active, inactive, and expired statuses. You will need to know the differences between those license status, again, active, inactive, expired. So again, alongside Rob Grantmeyer here with the Go School, we're going to continue on. We're going to now introduce to you in this segment the bosses, right, Rob? The head honchos that we report to, essentially. We refer to them as NCREC, also known as the North Carolina Real Estate Commission. We're going to talk to you a little bit about their structure, what they can and can't do, and the importance of NCREC to all licensees. Then we're going to get into a little bit about disclosure, starting with the Mac Daddy of disclosures, I would say, right, Rob? Agency disclosure. We refer to that as the WWREA, working with real estate agents disclosure. So we'll cover that, as well as some general license provisions. We'll get into those. And then we're going to touch a little bit on another topic that you've already learned from, I believe, Unit 7 of your textbook, a little bit more on agency, such as, again, buyer's agency, dual agency, designated agency. Yes, all of those terms coming back to mind. And then we'll conclude today's segment on a little bit of prohibited conduct of licensees, what you guys, when you earn your license, can't do, what's prohibited. So I think we're ready, Rob. Welcome back. Glad you're here. Tell us about the head honchos, NCREC, the Real Estate Commission.
All right. Well, thank you, Jason. Wonderful recap there. The North Carolina Real Estate Commission, very interesting organization. They're headquartered in Raleigh over on Navajo Trail. I always tell my students, right across the street from the Denny's, right? Everyone's like, oh yeah, the Denny's on Wake Forest Road there, and right up the couple blocks from Trader Joe's. And the Real Estate Commission is a really well-run, I think, fair organization. They hire some outstanding people, a lot of former educators, real estate educators, some very successful real estate professionals move on to work for the Real Estate Commission. And what I always like to tell my class is when we say the Real Estate Commission, what we really mean is 9 actual commissioners who are appointed, politically appointed positions. Those are the 9 commissioners. And then they also have, depending on the year we're in, give or take about 50 employees. So when we say the Real Estate Commission, we don't mean just the 9 commissioners. We mean the 9 commissioners plus the full-time staff that works at the Real Estate Commission in Raleigh. So they're a well-run organization, really good people involved. And remember, if in doubt, their purpose is to protect the public in dealings with real estate. So if, heaven forbid, Jason and I did a transaction together and one of us was unwilling to pay the other one, we don't call the real estate commission about money that an agent owes me or whatever. Their purpose is to protect the public, specifically what I like to call mom and pop, private citizens, to protect them, to make sure that their interest is looked after in a real estate transaction, to make sure that brokers are following their fiduciary duties and that brokers are being honest and fair with everybody. So if you ever get a question about, well, the real estate commission, are they here to protect real estate brokers from each other? Are they here to promote the interest of real estate brokers? No, they're here to protect the public in dealings with real estate. So that's a good intro. As we said, there are 9 there are 9 politically appointed commissioners, 3 of which must be brokers. 2 members cannot be involved in real estate at all, right? So it's a good way of kind of keeping some neutrality there. We've got at least 3 actively licensed brokers and 2 who are what I jokingly refer to as civilians. They are not involved in the real estate industry at all. And then the other 4 can be any combination. So that's the deal. 7 of them are appointed by the North Carolina governor, 1 by the Speaker of the North Carolina House of Representatives, and 1 by the President pro tem of the North Carolina Senate. So that's how they get appointed. Once elected or appointed, I always want to say elected, but they're not elected. They're appointed by elected officials. Once elected, they serve 3-year staggered terms. So we're not replacing all 9 commissioners. We want some continuity in there. And so once elected, you will serve a 3-year staggered term. And so those are the actual 9 commissioners. Now, they don't do everything, right? If you call the real estate commission, Commissioner Johnson or Commissioner Williams is not going to answer the phone, right? They have staff to handle that. But these commissioners, their main point of emphasis is voting on rules, any rule changes, and also disciplinary hearings. Disciplinary hearings, if Jason or I, heaven forbid, did something we're not supposed to do, we might find ourselves in a hearing in Raleigh, over there on Navajo Trail, right across from the Denny's, and might find ourselves in a hearing with these commissioners to answer for our activities. And so that's really their main point of emphasis there. They also can vote on schools, or not vote on schools, but they can also approve schools, approve if somebody applies for a broker's license and the real estate, the actual staff at the real estate commission maybe says this person has questionable character, they're not sure whether or not to approve that person, then it might come into the periphery of the real estate, the 9 commissioners to meet with that person, talk to that person to see if they do in fact think that person has the necessary character requirements to receive their broker's license. So that's our commissioners. Anything you want to add to that, Jason? Anything I might have missed there?
You ever met one of the commissioners?
Ironically, no. I've been around for 22 years and I've never met one. I don't attend the meetings or anything like that, although I know I should, but I've not had the privilege yet of meeting one. How about you?
I haven't. Yes, they're kind of untouchable celebrities in a way in our industry, But yeah, I'm going to make it a point to meet one day. But yes, 9 is your magic number here. Again, when we think that there are numbers specifically that you're going to need to remember, again, 9 is the number for the amount of commissioners that are elected. And then it would be a good idea to kind of memorize specifically how that 9 is broken up into, such as what we see here, the 3 members and the 2 members and 7 are appointed by the governor, et cetera. I think you mentioned, I was going to say, you did mention something about at least 2 cannot be involved in real estate, right?
Yes, sir. You got it
there. And then, like you said, too, it's not just these commissioners who are running the show. There's a lot of other departments, if you will, that are helping our day-to-day licensees in our schools, such as us, with administration of programs and like the pre-licensing program. So They do a lot. So yeah, but again, also too, what you said earlier, their main purpose is to protect the public. So you guys will be tested on questions like, if you have a dispute with another broker involving anything such as commission payouts, don't call us, right? The
Exactly.
NC Rec does not want to hear that or cannot do nothing about that. Instead, let's talk a little bit more about what specific powers they do have.
Sure. Yeah. I like to call it checks and balances, right? Just like we have a three-prong government in the United States, we've got the judicial branch, the executive branch, the legislative branch. Well, for a real estate broker, there are certain things the real estate commission can do if I misbehave, and there are certain things that only a judge could do. For example, if I misbehave and I, let's say, take advantage of a client and cost my client $20,000 in potential income, the real estate commission cannot, what we call, mandate reimbursement. They can't say, Rob, you better pay this person back the $20,000 that you owe. They can't do that. That's not within their powers. Their powers are, they can discipline my license. However, they have the right to censure my license, to reprimand my license, to suspend, or to revoke. And so I think people see a lot of questions, both in the school exams and the PSI exams, about what can the real estate commission do? Can they fine me? Can they force me to pay a client or a customer back money I owe them? No, they can't. That's not to say it can't happen. It just, there's a separate entity. It would be their district court or small claims court where that action would be decided. But the real estate commission has a fairly singular focus when it comes to what they can do to a real estate broker, and it's disciplinary action. And in some ways, that could be worse, right? I mean, if they have the power to suspend my license for months or years, they have the power to revoke my license and say, you're finished. You're no longer going to be able to represent the public in these real estate transactions. So although they can't force me to pay someone back, they very much have the power to affect my ability to work as a real estate professional. So it's kind of interesting. They, of course, license real estate brokers. They're the ones who issue the license. When I say that, when I talk about these powers, of course, I'm saying not just the 9 commissioners, but the staff as well. They approve real estate schools and instructors. Both Jason and I have been blessed to go through that process of getting approved. Jason's got to do it as a school and as an instructor. So he's fortunate. He's got to do it twice, right?
Right.
Good times. And they release every month, they put out a bulletin, a real estate bulletin that really is essentially only sent to real estate brokers, but it is a great way to stay on top of whatever rule changes have happened, any big controversial things that have happened in the last 30 days. And of course, you see the disciplinary action. If, for example, if my license had been reprimanded by the North Carolina Real Estate Commission, I would be featured, not really featured, but I would be listed, the crime blotter, as we call it, on the back of the real estate bulletin. And so the big part of what they do is educating and informing the public and real estate brokers. They regulate real estate business activities. They vote on rules, changes. And then here's a big one that's kind of sneaky. It occurred to me one day, I said, what if I don't have a broker's license? They're going to take away my license. I don't have a broker's license. What are they going to do? What are you going to do, Real Estate Commission? And here's what they can do. They have the right to investigate the suspected real estate brokerage activities of unlicensed entities. I know a guy who got a letter from the Real Estate Commission saying, hey, it's come to our attention that you have been practicing brokerage without a North Carolina broker's license. He was helping friends negotiate purchases for real estate, and they politely said, sir, you need to refrain. You need to refrain from doing that. And he did. He did refrain from doing it. Had he ignored their warning, they could have sought what's called injunctionary relief. That's a big phrase that you might see, not a frequent phase, but a phrase you might see that you would see in the Appendix A. Injunctionary relief is to basically go to a judge. They could take this person to court and have a judge fine this person if they continue to practice real estate without a broker's license, right? So they do have that right. They don't just discipline real estate brokers, they can also investigate unlicensed entities and say, hey, you need to shut this down. If you want to be a broker, go get a broker's license, right? So they do have that right. And as we've emphasized, and I'd say about 99% chance you'll be tested on this last point, they do not settle commission disputes between brokers or issue disciplinary action from these disputes. If Jason owes me commission or I owe Jason commission or whatever, what our first option would be to take that to the arbitration board of the National Association of Realtors. And if that doesn't work, we could take it to small claims court or district court. But the Real Estate Commission does not mandate reimbursements. They do not fine brokers directly. They simply basically have disciplinary hearings. If Jason or I violated North Carolina license law or commission rules, well, now the Real Estate Commission is interested. But when it comes to commission disputes, that's not in their order of business.
Yeah, and I love how you mentioned their bulletin. You know, that's one of the most overlooked resources, in my opinion, that the Real Estate Commission produces. Such a great learning tool, and I've even promoted it among our students as a great learning tool, whether it is simply just reading the disciplinary actions, because there's a lot you can learn. You learn what not to do because you don't want to end up in this disciplinary action segment of the bulletin. So definitely a worthy source to look into. It's published, you know, for the public really too on the NCREC website, but definitely don't overlook, excuse me, the bulletin.
Right.
Yeah. So what I'm hearing you saying, Rob, is NCREC sets the rules, and if we break the rules that they set, then we can get disciplined for that, and it will impact our license. Let's dive deeper into how it will impact our license. What are, again, those actions that they can take?
Sure. So there's 4 listed here. To censure your license is to express severe disapproval of someone or something in an official formal statement. And then they move up to a reprimand, which is an official scolding by formal statement. You'll see, I'd say the majority of the people you see in the bulletin usually end up with a reprimand. It's a slap on the wrist, don't do this again. Little bit of maybe a public shaming there, but probably well-deserved public shaming. They could suspend your license. That's happened to a couple different brokers that I know, luckily not that many. All right. They could temporarily withdraw it and then reissue it after a period of time prescribed by the Real Estate Commission. Let's say they say, Rob, you really messed up this time. We're going to suspend your license for 6 months and then you can have it back. Right. And then, of course, the kind of final straw would be to revoke your license, to call it back or rescind it. And as I recall, there's kind of 2 ways revocation could happen. It could be permanent revocation or revoked for, say, 5 years or whatever, and then you can start over and reapply if you want to. But they do very much have the right. And I know someone that it happened to where they permanently revoke the license and say, and they don't do that very often. That's reserved for pretty serious cases. And they say, you're out of here. There is no more. You have proven yourself too untrustworthy to really be involved in representing the public in real estate transactions.
Yeah. And I think what we see more often is people voluntarily giving up their license in an exchange for, I'm not admitting guilt or I didn't do anything wrong, but I'm giving you my license, right? Rather than having it revoked. Boy, you know people that have had revoked licenses. The last video segment, you were hanging out with bail bondsmen. I'm wondering what kind of crowd you hang out with now.
It's 22 years, Jason. Give it time. Give it time.
You've been around a lot.
And you just moved to the coast a couple years ago, so give it time. And and we'll get to you. And
All
so
right.
they also, as we said, they cannot fine licensees or mandate reimbursements to consumers for losses. A court could fine me, a court could mandate a reimbursement. I do want to point out one extra thing. Not only do they have these 4 disciplinary actions, they can also mandate education. And so they could say, Rob, you really botched this, you commingled these funds, you're going to have to go and retake the trust account class. Rob, you were allowing, let's say, a broker who I supervised to practice with an expired license, and they could say, Rob, we're going to send you back and have you retake the 12-hour broker in charge class, and or have me go back and retake post licensing 302 because I made a big mistake on the offer to purchase. Right. So they also have that authority to force you to take education requirements. And that's well within their periphery. They just cannot mandate reimbursements or fine brokers directly. Kind of the system of checks and balances there.
Should we insert here the one small exception when it comes to fining and the NC Rec, who they can?
Yes, good point. Good point. They can.
Tested on it.
There is one. There is one. I always like to say there's a special place reserved in the dark regions of for timeshare developers. And Jason, and just when you thought it couldn't get worse, I worked for a timeshare developer about 21 years ago. Not for long. I was only there for about as long as it takes to drink a case of good wine, probably. And then I was out. I got out of there as quick as I could, but they can. And I worked for a really good developer. They did everything right, but there are timeshare developers who, if they violate the timeshare act, the North Carolina Timeshare Act, the Real Estate Commission does reserve the right to fine the developer, not the actual salespeople who work in the timeshare business, but the developer themselves. The commission can fine them $500 per violation.
Yeah, and so just one small exception. You more than likely will be questioned on exams pertaining to just general fines from the Real Estate Commission. So anytime you see that in a multiple choice answer, you can kind of cancel that out as being the right answer again, unless it's talking about that timeshare developer that has messed up. But again, no fines coming from NC Rec. Just remember that their actions are right here: censure, reprimand, suspend, and revoke.
Yep. And make you take some education.
Right.
And what I've found, just as a side note, is even though they don't fine people directly, my experience has been on reading the bulletin for 20 plus years, they can certainly look kindly upon a broker who proactively rights whatever they did wrong. So say, for example, if I did cost my client $20,000, if I proactively reimburse my client, that may be, I can't speak for the Real Estate Commission, but maybe because I proactively took that action, that might be the difference between a suspended license and a reprimand. So they certainly take how you respond into consideration. Am I contrite? Do I realize I made a mistake? Am I eager to make amends? Or do, as sometimes happens when real estate agents get in trouble, they say, I did nothing wrong, you guys are wrong, I'm right, you're wrong. And if that's your mentality, then and you refuse to cooperate, then you're probably going to get the harsher sentence. Just kind of the way it goes there.
Right. And I've often looked at it too as, they may not fine you, but if they suspend your license and that's how you make a living,
correct,
consider that a big fine.
Yeah. And it's funny, in post licensing, I like to use a video of for some agents who were violating dual agency, and actually in another country. This is up in Toronto, and they call dual agency double ending, and people were getting in trouble for essentially the same thing people do here, which is to practice undisclosed dual agency. And in Toronto, they fine the real estate agents, but they do not seem to have the ability to revoke their license. And I said, it's almost worse here. They can't fine you, but if they take your license away, I mean, you're done, right? And so it depends on where you live, what's your real estate, what state you're in, what nation you're in, how the local real estate commission can discipline you. But absolutely, they can take your license away, and goodbye license. Now I've got a full list here. I'm just going to pull it up just for a quick peek at it. General Statutes 93A-6 breaks down all the disciplinary action by commission. And these are essentially all the things that you could do wrong. And so rather than read all of them, we're just going to hit on some of the highlights here. But before we do, I want to ask a quick question and make sure our friends out there in Zoom land are paying attention. True or false? An unlicensed person, I think I know this guy, has been helping friends locate and negotiate properties for sale in Atlantic Beach, North Carolina. That's your neighborhood. Yeah. The North Carolina Real Estate Commission has the authority to investigate his activities and take further action if necessary. So I'll let our friends out there think about it for a sec. And I'm going to say true. In fact, there's that term, injunctionary relief. They can seek injunctionary relief, which, by the way, that term's not confined just to the real estate commission. That's something an HOA could seek if somebody's breaking the HOA rules. That's something a zoning board could seek if somebody's violating the zoning. It's basically a court order, and the court can fine you sometimes $100 a day. They say, okay, pal, you want to sell real estate without a license? We've got Judge Anderson from Carteret County is now going to fine you $100 a day until you change course. And I suspect the unlicensed person would change course fairly quickly given that circumstance.
Yeah.
All right, so let's talk about the proof of license. All right, I just so happen to have mine handy. If I can get it here. Boom, here it is.
As you should.
I should, right? I'm required to. It's not optional. I am required to have my pocket card. This is our pocket card. No longer, Jason, you'll be pleased to know, I'm old enough that I remember when everybody's license had to physically hang in the real estate office, way back in the black and white television days, right? Back when people still rode horses around town. You literally, I called it the Great Wall of Licenses. When you joined a firm, they put your license on the wall at the office. And now they don't do that anymore. They just said, hey, instead of that, let's just make sure that each broker carries proof of really all it does is prove that I have a current license. It gives you my license number. It tells you my expiration date is June 30th, 2022. Tells you that S is my middle initial right there, and that B. So it doesn't, much to my disappointment, and I know you feel the same way. I would like them to go ahead and say broker in charge, BIC here, but they don't. They just say you're either going to say PB or B. And this is my proof of licensure. I need to present it for continuing education classes. I need to present it for post-licensing classes. And really, anytime that I'm practicing real estate, somebody has the right to say, hey, let's see that pocket card, buddy. And so whether you carry a physical copy in your wallet or an electronic copy on your phone, that's what we need right there, is a copy of that pocket card. So I'm sure you have yours as well, Jason. I won't make you flash it, though. We take your word for it. What I found is usually if you're going to show property, let's say at a gated community, they're usually not asking for your pocket card. They usually want to see your business card, but some places will. There are some communities, gated communities out there that will say, all right, well, if you want to go show this house in Landfall or some gated governors club, that we want to see your pocket card and your business card to make sure that you actually should be in this neighborhood. So that's our physically or electronically carrying our pocket card while engaging in any brokerage activity. That's a rule. That's real estate commission rule. Now you must produce this card upon request, including, as we said, entry to your education courses. Now we no longer have the Great Wall of Licenses that we had in the year 2000, but the real estate firm must display its license certificate in each office. So Every firm location must have a copy of their firm license displayed in the office. So that is a rule that they must do. That's the only license certificate that must be physically hung, as opposed to the good old days when we all had to hang them.
I can't imagine that in today's scene where you've got firms with 200-300 members, right?
I know, it's crazy, right? It's crazy. Could you imagine having a wall with two or three? I guess they'd have them in separate locations. They didn't maybe all have to be hung together, but that's where the old saying, hanging your license. I'm hanging my license with Prudential or Coldwell Banker or Paracle. And so that's how my firm did it, because we only had about 30 agents. So we put them all on a wall. And I used to walk by and be like, yeah, check it out. Because there was some big players in that office back in the day. I got lucky that even though I was a nobody, I got hired on with basically the best firm in Wilmington, the most productive, top earning firm back in the day. And I was like, yeah, that's my license on the wall next to these $20 million producers. And it was exciting. But then they said, nah, let's take those down and just carry your pocket card.
Much easier.
Much easier, right? And so also, if we're talking about changing your name or your address, right? And all licensees must notify the real estate commission in writing of each change of business address, personal name, or trade name within 10 days of that change. So naturally, there's a form for that. You could go on the Real Estate Commission website and submit a form to change your legal name change, get married, divorced, whatever, or change a business address, change your firm, whatever. You need to notify the commission within 10 days.
I've often thought that was an interesting number, 10, 10 days. Definitely, again, another number you're going to have to remember, 10 days. But I say it's interesting because of the next number you're getting ready.
The next number, right? It's like an appetizer. It's like an appetizer before they bring your big ribeye steak, because the next one, here's the sizzling steak right here, 60 days. I'm like, well, 10 days if you get married, 10 days if you move, but 60 days if you are convicted of any felony or misdemeanor. You must notify the real estate commission in writing within 60 days of the conviction. And I'm sure you do this too, I emphasize convicted, not arrested, right, not charges filed, right, not suspected of, convicted, meaning gavel, bang, bang, I find Mr. Grantmeyer guilty of such and such, and boom, that's it. You must notify them within 60 days of that actual conviction. And people sometimes get it nervous, like, well, I had a speeding ticket. I got a ticket for going 55 in a 45 or whatever. And I'm like, well, that doesn't count. We're talking felony or misdemeanor, actual felonies, actual misdemeanors. That's what you have to know, not moving violations. You must notify the real estate. And it doesn't mean that they're going to take your license away. They just want to know. They want to know. And if, let's say, you are convicted of DWI, then you're probably going to find yourself in Raleigh for a hearing, or at a minimum, they're going to want an explanation. They're going to want you to write them a letter and say, what happened? What happened here? We can't have you driving while impaired, carrying the public around with you. So they reserve that right to have you come to Raleigh for a hearing and potentially suspend or revoke your license. So that they take that, rightfully so, they take it very seriously. And then the other side is, and this one can be sneaky, is what if I also have a Tennessee broker's license, or a South Carolina appraiser's license, or a North Carolina cosmetology license, right? If I am disciplined by any other occupational licensing board, nursing board, cosmetology board, appraisers board, general contracting board from this state or any other state, right? If I receive disciplinary action from any other occupational licensing board, the same 60-day rule applies. And so again, it doesn't mean just because the North Carolina Cosmetology Board reprimanded me because I'm bad at doing hair color or whatever. I accidentally gave Jason purple hair, right? Something like that. That doesn't mean they're going to revoke my real estate license, but if I am disciplined by the cosmetology board or any other board, let the real estate commission know about it within the 60 days. They're probably going to ask me to explain what happened here and maybe have me come to Raleigh and talk with them. But everything I've heard, obviously I've not met the real estate commission, but everything I've heard from people who have, they're very reasonable. As long as you're reasonable, as long as you are doing your best and you're doing what's right, you're doing your best to do what's right, they're pretty reasonable about this stuff.
Right. I think it's time for a quiz question.
Quiz question. I like it. True or false? A North Carolina real estate broker must physically display their license in each office they're affiliated with. Well, those were the days, right? That was back when you could leave your door unlocked. But now we're going to say false. North Carolina brokers must carry their pocket card. Firms must hang their firm license in each branch office. So there you go. Firm must hang their firm license, but we, the regular old real estate brokers, provisional brokers, non-provisional brokers, broker in charge, whatever, we carry our pocket card. So there you go.
Very good.
Nice one. So speaking of, we already kind of touched on continuing education, but just to recap it here, active brokers, and by the way, not all brokers choose to be active. You could go inactive if that's your choice, but most people, in order to receive compensation, you must have an active broker's license. And other than your very first renewal period, for the rest of your career as a real estate broker, other than your first renewal period, beginning with your second renewal period, you must complete your 8 hours of continuing education each year no later than June 10th. So as we said, June's a big deal. Got to make sure you get it done by June 10th, right? Your renewal date is the 30th of June. Your CE date is June 10th.
Yeah, definitely always a good reiteration here of those dates, especially because there's 2 specific deadlines in June, and making sure you, again, keep those deadlines distinguished between what's what, right? Again, so CE again is due the June 10th and renewal is due by June 30th, no later than June 30th.
Yeah, and I wish I knew of a school who taught CE. I'm not sure of any. They're really hard to track down, but you might have success with the Go School of Real Estate. I hear really good things about their CE classes, so check them out, goschool.biz, right? And so provisional broker, as we said, that's the only time. It's the only time you get a pass on CE is your very first June. If you get your license on March 4th, today, I think today's the 4th. Hope today's the 4th. It is the 4th. You get licensed on March 4th, 2022. You don't have to do your CE this June. You will have to do it by June 10th, 2023. So that can be a little bit tricky there. And the CE itself, sometimes I see questions about that. Is it a 8-hour update class? No, it's a 4-hour update class that the Real Estate Commission publishes each year. And then it's taught by different real estate schools. And then you get to choose your 4-hour elective course. So 4-hour elective course, which you get to choose in 4-hour update. And what I end up usually doing is picking whatever elective happens to be on the same day that I'm taking the update, because I'm one of these crazy people that tries to knock it out in one day, but you can split them up. You can do them all together in the same day. Jason appreciates it when people wait until the 9th or the 10th to do it. That's his favorite scenario. And then also a couple other little known facts about CE. Some people think you have to pay your renewal, or no, they think that you have to pay your renewal before you do your CE. That's not the case. You can start doing your CE as early as July 1st.
Yeah. Or they have to take their CE before they pay their renewal.
Exactly.
And so, we remind you that renewal window opens up May 15th every year. And so if you haven't done your CE by May 15th, it's okay. Still go and pay your renewal so that you don't wait until June 30th and forget. But then you can, again, also meet the CE deadline by June 10th. So Yeah. Don't
It's kind of
forget.
ironic because I say it's like when you renew your license plate tags, you have to get your state inspection and then pay your renewal. And everyone kind of thinks our licenses are that way too. But no, you can do it in either order. You could do your CE as early as July, August, September,
Right.
October, and schools love it when you do that because they like anybody, they don't want to have 90% of the people do it the last 30 days of the fiscal year, but that sometimes does seem how it goes. So you can do it in any order. Just please don't miss that June 10th deadline, or you will have an inactive license on July 1st.
Yeah, and another time or opportunity here to remind our audience that this is different from post licensing.
Yeah.
Again, we see too many new licensees and students get confused the differences between post licensing education and continuing education. And as we mentioned before, post licensing has to do with your provisional license, dropping that provisional status and becoming a full broker status. Again, different deadlines on post licensing than there is on CE. Right here, we're only talking about CE, continuing education.
Right. A good way to remember that continuing education is literally a lifelong commitment, right? As long as you're going to be a broker, and for most of us, we'll be doing continuing education for life, right? And so the continuing, it's every single year after your first year. That is, post licensing is literally post the license exam. After you finish your license, after you pass your licensing exam, you have a year and a half, 18 months to do your post licensing. But you're exactly right. I'm amazed that we get all the way to the last day of class review, and it seems like 30 or 40% of the students are still confused over the difference. It's hard for me to believe that, but of course, I've been involved in this industry for 22 years. I'm sure that when I was brand spanking new, I felt the same way, even though I was easily confused about the different education requirements as well, because let's face it, it can be a little overwhelming with the amount of knowledge that you're taking on in the licensing process here.
Yeah. There's a fire hose there.
Fire hose. Yeah. I drank through the fire hose for a while. All right. So big one here, the WWREA. And I highly recommend, if you have the chance, go on YouTube, search Real Estate Commission, North Carolina Real Estate Commission, working with real estate agents. There's an hour-long video that they made back in the spring that has lots of great information on the new and improved working real estate agents disclosure. For example, we used to call it a brochure because it used to be a brochure. Now it's just a one-page front and back disclosure. And so we've changed that a bit. But this is arguably the most important thing. It's as important, I think, as anything else you're going to see in pre-licensing. It's when the Real Estate Commission investigates somebody for messing up. What I've been told is one of the first things they're going to look at is bring us your last 5 client folder, transaction folders, and show us your working real estate agents disclosures, because a lot of people don't, not a lot, but there are some agents who don't do the working real estate agents disclosure properly. Some folks never do it. Some folks like to do it at the last minute when they're ready to submit an offer. And both of those are doing it wrong, right? That's not the correct way of handling the working real estate agents disclosure.
So what's the purpose of this disclosure that, again, is a requirement from the Real Estate Commission? What would you, again, say is the purpose of this disclosure?
The purpose is, again, just like it's one of the few documents the Real Estate Commission actually creates themselves. And the ones they create is this one, the residential property disclosure, the mineral oil and gas disclosure, and all of those, the common thread is their consumer protection. They are meant to protect the public from making a potential mistake, or perhaps putting their trust somewhere where their trust should not be. And so I like to call this the Miranda rights. I am not the first person to come up with that. That's been knocked around by real estate teachers and broker in charges, and even the Real Estate Commission thinks of it that way. But the Miranda rights, when someone's arrested, is you have the right to remain silent. Anything you say could potentially be used against you in a court of law. Well, let's say that you show up to an open house, and I'm hosting that open house. And if I'm hosting that open house, I work for the seller. It may not be my client directly, that I may not have signed the listing agreement myself, but there's a great chance that my firm represents that seller. And so if you come walking into this open house, I need to warn you before you tell me things that could be used against you. Now, I don't need to meet you at the door and, hit you right in the noggin with this thing, but I do need to share this disclosure form with you before you share any confidential information, right? Before you tell me how much money you make, before you tell me why you have to be in this particular neighborhood. Someone A great example, I had a neighbor who was living in a what would you call that, a camper. They were living in a camper with 3 large teenagers and 2.5 large dogs. One of the dogs was like the size of my fist, but the other 2 were giant bear looking animals. And the poor lady, she was like, I mean, desperate to close on a property. That's the kind of information where if you find out that a potential buyer is dealing with some type of hardship, they're relocating due to a job, they tell you how much they're pre-qualified for, they tell you what their income is. Hey, you know what? Once they tell me that, I have a duty to share that with the seller. So at the least, the very least I could do is warn that buyer, hey, before you tell me that you're living in a camper with 3 teenagers and you're about to jump out of a window, before you tell me that you make 95,000 a year and are pre-qualified to buy a house in the $400,000 range, let me just pump the brakes a sec and say, listen, let's talk about who I represent and what you should share with me and what maybe you don't want to share with me. And who knows, maybe you'll choose to hire me as your agent. Even though my firm represents the seller, you could hire me to work as a dual agent, right? But if you're not going to hire me to be a dual agent, I would recommend that you get your own representation and that you don't share certain things with me that you would want to share with your own representation.
Yeah. Stop again. You have the right to remain silent. Yeah. You don't want to know that information when they, again, have not hired you specifically to represent them. So again, if you're encountering a potential buyer in the scenario of an open house, again, you are working for the seller. And so it is our duty to disclose to folks that we encounter in such a scenario or any given scenario where someone is about to tell us too much, right? Again, we're not talking about things about the house, how many bedrooms it has, what's the list price of the house, any and all facts about the house itself. Sure, we can talk all day long about that with, again, those that we encounter. But again, when they start spilling their guts, so to speak, or giving us TMI, as we teach sometimes, too much information. This is again where the real estate commission, has said, hey, listen, we need to make sure, again, because we're here to protect the public, and you have a duty as a licensee to do that with us. And this is going to be a major way that you're doing that, because we want the consumers to be protected. We want them to be knowledgeable about their rights when it comes to buying and selling real estate. And so they need to really understand agency, and again, who works for whom, and what comes with a relationship with a real estate agent. So,
and I'll put another flip on that and say, what if I'm going in, and this happens a lot, once you're established as a real estate broker and you're being interviewed as a potential listing agent, 100% of the time you need to be prepared to discuss the working real estate agency disclosure with the seller, because you meet with the seller, whether oftentimes at the property or a coffee shop or whatever, and they're going to talk. They're going to tell you why they're selling. They're going to tell you things about the property that they may not want the buyer to know. So that's why you need to pump the brakes before you tell me why you're selling, before you tell me your personal details. like, I guess, confidential information. Let's take a few moments, let's discuss how agency works in North Carolina, because here's why. A lot of times those sellers will interview multiple firms, right? And let's say I met with them this morning, and then Jason, who works for maybe a different firm, meets with them this afternoon. Naturally, they're like, we really like Jason. I'm like, yeah, everybody does. So they hire Jason. And now, because they've not hired me, I find myself working with a buyer this weekend who wants to go look at their house. Well, if they spilled a bunch of confidential information to me, without knowing that it can be used against them, they put themselves at a significant disadvantage. And so that's why it's super important to make sure anytime you're potentially going to be working with a buyer, communicating with a buyer or a seller, you want to make sure that you discuss this particular working real estate agent's disclosure before they share any confidential information.
Yeah. You know, what you have here on your screen, Rob, is super important. And that term, first substantial contact, that is certainly a term that you are going to see in testing, both here in the course as well as on the state exam. And again, understanding or being able to identify an example of a first substantial contact interaction. I think the terminology here is a little misleading, unfortunately, because it's saying first, right? And you even have it capitalized, first substantial contact. And so a lot of students really kind of interpret that as, oh, I meet you at the door and you tell me your name. Not exactly, no. Just like you said earlier, you're not going to assault them as soon as they come in and start talking about their rights necessarily. But first substantial contact, again, to reiterate that, is prior to the disclosure of any confidential information. You describe it as PTM. Tell us about that. What do you mean by PTM there?
Sure. Price, terms, and motivation, like what you're willing to pay, what you can afford to pay, what terms you're seeking in this transaction. And the big one to me is motivation. If somebody's living in a motel room, paying $180 a night because they have no home, if somebody's being transferred for their job, they got to be in Seattle, Washington in 2 weeks. That is highly motivating factors. And you definitely want to warn people not to share that type of motivation with you until they have had a chance to understand because the average person doesn't realize how agency works in North Carolina. I'm always amazed. People think realtors just are all the same. We're just like public servants who are just here to help everybody, but that's not the way it works. You know that by now, if you've made it this far in the real estate course. You know, we are fiduciaries, which means we have certain duties to our clients that we only have to our clients. And so that's why we have to be careful with that responsibility, and we don't want to take advantage of people's trust.
Right, right. So we spend a lot more time in class on this particular form, this disclosure, and you see copies of it. But for the sake of this review, we want you to, again, take away from the requirement, again, of when to disclose, agency, again, working with real estate agents, disclosure, understanding specifically what first substantial contact looks like. And you know, like we end here, one of the important points, and I love how you've identified this as a problem topic, or NC Rec has identified this as a problem topic. Again, to reiterate your arrows there with the PT in it. This disclosure does not automatically put you in an agency relationship. It's not a contract. It's nothing legally binding. It's simply a disclosure. You are disclosing something. You are, preventing that person in front of you from continuing to spill their guts, so to speak, with PTM information. So that, again, you want them to have a thorough understanding of what agency relationships look like in North Carolina, and allow them to choose what types of agency relationships they're going to be in. But it doesn't create that agency relationship. It's not going to bind them to you or your firm in any way. So good point there as well.
Right on. Great. All right. So speaking of agency, types of agency, perfect segue there, buyer agency. And I know you've all seen it before, right? You've all seen this when you reviewed Unit 7 in the Dearborn textbook. And it's fairly important. I always tell people this is pretty much where you're more than likely, good chance your first paycheck as a real estate broker, certainly in general brokerage, would be working as a buyer agent, someone who exclusively represents the buyer in a transaction. It seems to be easier, especially nowadays. It's easier to find buyers who need representation than sellers who need representation. So there's some unique things about buyer agency that you need to remember for the exam and for your career. Buyer agency, for example, is the only type of agency relationship that can start out as just an oral agreement, right? An oral agreement where, hey, I'm going to go show property to somebody I met this afternoon. They walked into our real estate office. They're in town for the weekend, or they're in town for spring break, and they want to go look at a couple of houses because they love the area, and they're thinking about buying an investment property and using it for personal vacation as well as investment. Fine. I tell you what I would lead with. I would lead with, of course, I wouldn't, again, hit them over the head with the working real estate agents, but I would definitely want to review that with them before we go out and look at houses. But once we've reviewed the working real estate agents, I'd probably next want to make sure that they have a chance to speak to a professional loan officer and find out what they're pre-qualified to purchase. But once we've got those two big hurdles done, we can now go look at properties. We do not need a written agency agreement for me to go out and show property to this potential buyer. And really, I'm already in a fiduciary, even though I don't have anything in writing yet, I do have a fiduciary duty to that buyer because they've entrusted me with their confidential information, and they're going to allow me to work as their buyer agent. Now, really super important, the Real Estate Commission really wants to emphasize, I need to explain to that buyer how agency works, which I've already done that, but I also need to explain specifically buyer agency, such as, hey, there may be potential, if I'm out showing you houses this afternoon, we may see one that's listed by my firm. So I need to discuss the terms of buyer agency, even though we haven't written our agreement yet. I need to discuss the terms of buyer agency before I go out and start showing property to this buyer.
Yeah, very important. And you've got another specific point to make about oral agreements, right? Because this is where it can get a little confusing.
Yeah.
Oral versus written.
Now, here's the downside of that. I'm personally, I enjoy flexibility, right? I mean, I would wear flip-flops 365 days a year. I'm not the button-down type usually, but I like oral buyer agency. But here's the downside. The downside is that I cannot restrict this buyer's right to work with anyone else, nor can I bind the buyer for a specified period of time. And if it's never happened, obviously, if you're watching this video, you've probably not worked as a buyer agent, but most buyer agents you'll talk to will get burned at least once. They'll get burned at least once where they meet a buyer client, they don't have a written agreement, they go out, they show property to this person, and the person ends up, hey, I just remembered my sister's got her broker's license. She lives in Charlotte. I'm going to have her write the offer for me. Yes. Sorry, Charlie. And it's a tough break. And there's really nothing you can do about it because you did not have any type of binding agreement, right? There's no binding exclusive buyer agency until it's committed to writing.
Yeah.
So it happened to me. Probably didn't happen to Jason.
No, it does. It does. Absolutely. And I think it's going to happen to everyone who's practicing in real estate. There are scenarios like that happen all the time. But then also too, I look at it as I relate agency to dating, right? It's kind of like dating out there in the dating world. And sometimes before you make a commitment to someone, you want to, take them on some dates, or in this case, show them some homes, have some consultation with them, and, make sure that you're compatible with one another. So I kind of look at it like that as well. So There are some agents out there that I know that will not put anyone in their car or talk to anyone much further than disclosing agency until they have signed in writing, a commitment to be their buyer's agent or be their listing agent. And again, I kind of make sure that we court one another a little bit because if it
Right.
turns
Make
out
sure
to be
it's a good fit.
yeah,
You
it's
want to
got to
make
be a
sure
good
it's a good
fit
fit for both
for not
parties.
only them, but also you, the agent, because there's some clients you may not want to work with. It may be a little bit too impossible in what they want, or perhaps have different styles or preferences, and you can match them up with another agent. But yeah,
Absolutely. And then one other key detail to take away from the oral buyer agency, we must, all right, we said we can do the WWREA, put them in touch with a lender, go show them some houses. That's great. But the one thing we cannot do is actually make an offer on a property on behalf of this buyer client until we have a written agreement.
yeah,
Right. And so whether you want to do it at the beginning to avoid getting dissed by the buyer, because that happens, or whether you want to wait and go on a few dates. I'm more like Jason in that sense. I'm more like, let's just kind of see how it goes and make sure that you're not going to make me miserable and vice versa. And so, but regardless, it must be reduced to writing before we make an offer on a piece of property. Very important.
yeah. So we're talking about agency. We're disclosing again the benefits of buyer agency specifically in this scenario. We can come to an agreement orally for now that I will represent you and understand here's what that includes. But when it comes down to the part of our journey where you actually have found the one, we have found the house that you have fallen in love with, you're ready to make a commitment, thereby offering something for the purchase of that home. Before we do that, we've got to take what we've talked about orally and put it in writing so that, again, it's official that me, along with my firm, are going to represent you during this purchase. So again, very important factor here. It's got to be in writing before, and I love how you've emphasized before here, because again, some students may kind of glance over that, but before making an offer, before presenting an offer to a seller and a seller's agent. I believe you've got one more specific point about oral buyer agency agreements here.
Yep. And we touched on this briefly a second ago. We were like, listen, don't put people in your car and drive them around like this is Uber, right? This is not Uber. This is not a taxi tour, right? We need to, before we get in the car and ride around, or even you follow me, because nowadays people don't ride with each other, apparently. Back in my day, we did, but nowadays everyone drives. You probably end up with like a 3-car convoy where the agent's driving one car, the one spouse is in one car, and then another spouse. It's just, yeah, that's how we do it in 2022. But anyway, before we go there, before we start looking at properties, we must have an agreement on compensation, right? Not necessarily a written agreement, but we need to at least have a conversation, a dialogue about how buyer agents get paid and whether or not this buyer is willing to allow a dual agency situation, right? Because if they're vehemently opposed to dual agency, then we don't need to go look at any properties listed by my firm, right? So we need to discuss how buyer agents get paid, whether or not this particular buyer is open to dual agency. We need to have that conversation before we go out and start falling in love with houses. I think that's very important.
Yeah. And these are components of a written buyer's agency agreement, of course, along with others, but at a minimum, before we simply settle with an oral buyer agency agreement temporarily, these are at a minimum, again, what you got to have included in that, right?
Right, absolutely. Because a very common misnomer is that buyers never pay their buyer agent. You'll hear real estate agents say that frequently, and that's not always true. There are situations where buyers are expected to compensate their agent directly once they have a written agreement. Let's say, for example, a buyer decides to purchase a for sale by owner who's not willing to pay any commission, and there's a written agreement between the buyer and that buyer agency firm. Well, in that situation, good chance the buyer has agreed to compensate the firm directly. So I think it's only fair to have that conversation with the buyer at the beginning. And so they're not feeling like we, sabotage them later if it comes into, and that's rare. Don't get me wrong, that's rare. The buyer agent is usually compensated by the seller or the listing firm, but there are instances where they are not. And so it's only fair to discuss that with the buyer at the beginning.
Yeah. And I have a feeling we're going to see more of those instances in the near future.
Yes, I agree. From what
change.
I gather, it's next level stuff. Or from what I gather, there's already kind of that tendency in certain California markets where the sellers are saying, I'm going to cooperate nothing with the buyer agency. And the seller agrees to pay the listing firm. And then the any compensation paid to the buyer agent is 100% on the buyer. So who knows how things will shake out.
Stay tuned.
Stay tuned, right? True or false? North Carolina real estate brokers do not have any fiduciary duties to their buyer until they have a written buyer agency agreement signed by the buyer. I'm going to have to say false here, right? Because even though we're in just an oral buyer agency agreement, I am still in a fiduciary relationship. Now that could change. Here's how that could change. If we reach the point where this buyer's ready to make an offer and they refuse to sign a buyer agency agreement, now my allegiances may change. But if I'm in a oral buyer agency agreement, they've entrusted me, and that is in fact a fiduciary relationship until something happens to change it. So please keep that in mind.
Yeah, and this is one of those questions where you see the words there that should stand out. And to me, the word any, right? So they do not have any fiduciary duties. And so that's one of those, that's too definitive to be true, right? And these are the types of things that you want to look at in questions. That's because real estate, for the most part, it's really black and white, but there's some gray areas as well. So again, too definitive there. That's a red flag for me. So I would have said false too.
Yeah, right. Exactly. Watch out for that. Cool. All right. Now, dual agency. Believe it or not, it's one of my favorite topics. A lot of people are terrified of it, but I've had to look at it for so long. I've been engulfed in it for so long, and seen so many instances of dual agency that I can finally say I get it. I didn't always get it, right? I've stuck my foot in my mouth a couple of times trying to explain dual agency, but I feel like I pretty much get it now. And what you've ultimately have here is if you look down at the bottom, you've got one firm, right? It could be one individual agent or what we call a sole proprietor like me, or one firm representing two opposing clients in the same transaction, right? And so let's say it's Paracle Realty is the firm in the middle here. They've got a seller who owns a house in Cary, and Paracle Realty also represents the buyer. This buyer is endeavoring to purchase that seller's property, and Paracle Realty now is going to serve as the agent for both parties. And that's tricky, as you would expect. That's why people are scared of it. It's tricky, right? Because if we're going to serve as dual agents, then we have to make sure that we are fair and impartial to both parties. One time I stuck my foot in my mouth was someone asked, can a dual agent help their client negotiate? And for some dumb reason, I thought, well, yeah, no, you can't. A designated dual agent, which we'll talk about in a sec, they can help their client negotiate. But as a dual agent, you're what I like to call a referee, right? You put the striped shirt on and you are now a referee. It'd be kind of messed up if a referee is helping one team more than the other, right? A referee's job is to be impartial and to treat both teams equally, call it the way you see it. And that's how a dual agent is expected to perform. And you need the informed consent of both parties written prior to showing the property if written buyer agency exists. So both the seller client and this buyer client are going to need to agree in writing to dual agency. And I like the term informed consent I don't know if everyone truly gets informed consent. Some people just say, let me send you this agreement via DocuSign, and it just says click here and here, and that's what they consider informed consent. I don't like that idea. I think you need to make sure this seller understands what it means, and this buyer understands what it means to be involved in a dual agency transaction.
Yeah, I mean, because like you said, it's taken you a long time. It's taken me a long time to fully understand it. So imagine when we're presenting this to clients, on the spur of the moment, perhaps in some cases, they may not get it. So it's definitely one of those areas that you want to master. You want to be able to articulate this confidently and easily so that it could be understood by your clients that are possibly impacted. But a lot of folks don't practice dual agency, though. A lot of firms may not even practice dual agency. They'll say, I only represent the sellers, or I only represent the buyers, but never both. And in those cases, one of the clients has got to go find another representation outside the firm. So it's a tricky subject for sure. But you think about too, you've got some larger firms that have a pretty large market share of the inventory, and if you are a buyer also hiring that firm to represent you as a buyer's agent, chances are that firm's going to have a listing that you want to see and possibly buy. And so that's again where you'll need to be comfortable with agreeing to dual agency in those cases. But yeah, definitely important for the agent, himself or herself, to really get comfortable with the concept of dual agency and how to explain that, how to articulate that to folks.
No doubt, no doubt. And speaking of the different forms of it, this, I think, if your firm is going to practice dual agency, I think most large firms would prefer what we call designated dual agency. Yeah. And I like to really emphasize here, because dual agency, just straight dual, no designated, means that whether or not there's two agents involved or one agent involved, you are a referee. You are impartial. You are not allowed to advance the interest of either party to the disadvantage of the other, right? And so designated dual agency, that changes it a bit, right? And designated dual agency, there's still only one firm involved, right? Let's say it's Paracle Realty, Better Homes and Garden Paracle Realty. Let's say Jason has a listing over in McGregor Downs. So it seems like Jason's type of neighborhoods, classy joint. Jason's got a listing over there in McGregor Downs. Just so happens I have a buyer client who's looking to purchase a home in McGregor Downs. Jason and I both are affiliated with Paracle Realty. Well, as long as our firm will allow it, and as long as our clients will allow it, there's a great chance we will work as what's called designated dual agents. So there's one firm, but two different agents involved. And a huge difference between dual agency and designated dual agency is that Jason and I, if we're designated, we're no longer referees. All right. We take the referee shirts off and we put on the advocate shirt. We're now what I call an advocate for our client. Jason is going to help his seller negotiate, help his seller get the best possible price and terms. And I'm going to help my buyer. I'm going to advocate for my buyer, do everything I can to get my buyer. Now, we're going to fight fair. We're not going to be, doing anything unethical or illegal, but we both now can advocate for our clients. And it was actually a Paracle agent and I were talking about this one time. And I was talking about the very fact of how do you explain dual agency to a client. She said, well, designated is a much more digestible version. If you're telling your client, Jason's telling his seller client, hey, my firm practices designated dual agency. If someone else from my firm, another agent from my firm brings a buyer to the table, you don't have to worry about sharing me with that other person, right? So that Jason will stay on the seller's side the whole way through, and I will stay on the buyer's side the whole way through. So you don't have to worry about sharing your agent with anyone else.
Right.
Yep. So, and there are a few little, pretty much the one big no-no that where you could not be designated is if you're a provisional broker, you of course cannot be designated opposite your own broker in charge, right? So if Jason was my broker in charge and I was still a provisional broker, then one of us is going to have to refer our client to another agent within our firm, because he and I could not. We could work as dual agents if the clients are willing to allow that and the firms are willing to allow that, because we could both serve as referees, but I could not be an advocate for my client going against my own broker in charge, because, hey, my broker in charge is my supervisor. He's my lifeline. He's who I'm supposed to call when I have problems. And so that would obviously be too great a conflict of interest.
Yeah, so that is the big scenario that cannot occur when it comes to designated agency. Surely going to be tested on that. I have no doubts there. But designated agency, yeah, we'll practice that all day long, right? Because we get to keep, you call it advocate, I call it coach. I'm going to remain a coach rather than turning into a referee instead. I get to continue to coach my team to the winning goalpost. We're going to beat your team. And so, yeah, that gives us the opportunity. Now, kind of a sidebar here, because we've talked about perhaps before now, and we'll continue talking after this about what can be shared about the firm's clients, right? We're all in the same firm. The client belongs to the firm. Although you're representing the firm and dealing one-on-one with that client, we have to be careful in cases where we're sharing too much information about our clients in case this scenario happens. For example, if Rob, your client is a buyer and my client is the seller, but yet I have had too much water cooler talk with you about my seller and how much of a situation this is, that is, or whatever. And so you've gained too much information basically that can be used against us. Then I would say, no, we're going to have to designate someone else as your buyer's client, buyer's representative there. And that's where I would go to my BIC and be like, BIC, Rob says he can handle this buyer, but then I've told Rob too much. He's learned too much about my client, our seller client. May not be the best interest to do a designated dual agency in that combination, right?
Correct, absolutely. And in that situation, it's not all bad news for me. I could refer it to another agent within our firm, most likely get paid a referral fee for that. Ultimately, if in doubt, choose the answer on your test that is in the best interest of the client, right? It's all about what's in the best interest of the client, not the best interest of me, not the best interest of Jason. We want to do what is fair and best interest of the client.
Absolutely. Good.
All right, so let's true or false it here. A provisional broker may serve as either a dual or designated dual agent in a real estate transaction per North Carolina license law. I'm thinking probably so here. Let's see. True, although they could not be designated opposite their own BIC. And of course, any broker, provisional or otherwise, cannot be designated if they have too much confidential information about the other party.
Yeah. So don't get thrown by the PB or the provisional broker in the test question and what they can and can't do. The only time they can't practice designated or dual agency is when they're up against their own supervising BIC.
So. Right. And that's a common mistake is some people think, oh, provisional, you can't do that. You can't represent this person. Well, yeah, you usually can. There's not that many limitations on provisional brokers in terms of what they can and cannot do. So I've found some of the more successful people who are making a great deal of closing a great deal of transactions can sometimes still be provisional. And so we don't want to put too much training wheels on the provisional broker, but of course not designated opposite their own BIC.
Right.
For good reason.
Mm-hmm.
So, and this is what our friends, I was watching that video. If you take my post licensing 301, I've got a caught on camera. They call it agents illegal double ending is what they call it. Some states they call it dual agency double ending. And there's some sneaky people that got caught on camera up in Toronto, and I'm sure it happens here too, practicing undisclosed dual agency. And what that means is you're working for more than one party without the informed written consent of all parties. So real estate agents acting for more than one party in a transaction without the consent of all parties equals undisclosed dual agency and is prohibited by law. So make sure if your firm is going to represent the seller and the buyer, it's very, very important that you have the informed consent of both parties. You can't force anyone to agree to dual agency, right? If they're not willing to accept that, then we need to work out another solution.
Yeah. One of the perhaps the most common word in our industry is disclose. Disclose.
Yeah.
There's so many times where we are disclosing or having disclosures completed, or having our clients understand certain disclosures. Disclose. When in doubt, disclose. Never keep anything, especially like this, secret from one another, secret from the parties involved. Ooh, I wouldn't have.
Right.
Well, I'm curious, what's the outcome of those two jokers?
Yeah, that's really, really bad news. The Real Estate Commission takes this very seriously. This is in fact a misdemeanor in North Carolina as well to practice, just like it's actually a misdemeanor to pay an unlicensed person a commission. It's a misdemeanor to practice undisclosed dual agency. So it's very serious business. And a very common example where this could go down is somebody shows up at the open house and I'm like, yeah, I'll make an offer. I'll write an offer for you. And I just kind of, the big benefit to double ending or dual agency is double commission for either the individual or for the firm. And so that's why we need to make sure people understand I'm working for both parties. If I'm working for both parties, I cannot promote your interest to the extent I could if we were practicing single agency. So you have to be very careful with dual agency. You have to make sure the parties understand it, and you have to make sure that you're performing your duties properly and not promoting one party's interest over the other.
Right. All right.
All right. Speaking of prohibited conduct, here's a great philosopher from the 90s, Dr. Chris Farley, I like to say. And I like to use him as an example of misrepresentation and omission. But before we get to those, let me just talk about willful and negligent, right? Normally, what you're going to be asked on a test, they're going to give you a scenario, something like this. Broker Jason is aware that a seller covered up termite damage with fresh paint, and broker Jason never disclosed this fact to a potential buyer. Well, so the first thing you have to ask yourself in that scenario is, was broker Jason acting willfully or negligently? And willful is kind of hard to prove. In that situation, if the question says broker Jason is aware of an issue, well, then it's probably willful. Willful means you knew something was wrong and you acted intentionally. So if broker Jason sees it for himself, if he is told this information directly by the client, well, then it's willful. If it's something you should have known, right? If, let's say, for example, there is an issue at a property, maybe some signs of flooding, and you never asked, they never told, don't ask, don't tell, whatever, and you should have asked, that could fall under negligent. You should have known, you forgot, or you made a mistake. So the first two are a little bit trickier, in my opinion, how to discern between, was someone acting willfully, was someone acting negligently. I usually tell people to lean towards negligent unless you're sure this person knew, right? So for example, if I go to show a property and it's really hot in the house and I never bother to check to see if the air conditioning works, that's actually considered negligent because I should have known better. But if I turned on the air conditioning unit and black smoke came out and the seller said, oh, that thing doesn't work, turn that off, well, then it's willful. So it's kind of like the burden is on the prosecution. The burden is pretty stiff to prove willful. But the next two are super easy. That's where Dr. Farley helps us out, because misrepresentation can only happen if you open your big yapper. All right. That's a direct quote from Dr. Farley there. Anytime you open your big yapper, or if you press send on your email or your text message, you are either representing or misrepresenting. So if broker Jason never says anything about the termite damage, that would not be a misrepresentation because he did not speak to the matter one way or the other. If broker Jason said, there's no termite damage that I'm aware of, that would be a misrepresentation because he opened his big yapper or he pressed send. Now, an omission is when you keep your big yapper shut or you do not press send, right? So you can't misrepresent something unless you communicate. And if you don't communicate and should have, then it's more than likely an omission. Anything you'd like to add to that scenario, especially now that we know you covered up that termite damage, Jason?
No, a great explanation. And I love how you have 3 red stars on this, right? That must mean that's pretty serious stuff right here, right?
It comes up a lot. And
Comes up a lot, yeah. And students often get these kind of confused. So really be able to identify some examples of each of these. But I love your inclusion of the yapper. That's going to help stick with me now. If you opened your yapper, you misrepresented something. If you didn't open your yapper, you kept your yapper shut, you are omitting something. And then whether or not that was willfully done or negligently done, you'll have to determine that too, based on the scenario provided. So definitely study up on these terms as part of your prohibited conducts.
And it kind of goes in order. Willful, if you do something willfully, you're probably going to get a stiffer penalty than if you do something negligently. Right. So the worst case scenario would be willfully, I knew that the heat pump doesn't work, let's say, for example, and I tell the client that it does. I go, no, a heat pump's fine. It works great. I willfully misrepresented something. That's pretty much about as bad as I could be in this scenario. If I should have looked further into a situation and instead just kind of looked the other way and kept my mouth shut, that's probably a negligent omission. I'm still going to get in trouble, but it's not as stiff a penalty more than likely than willfully misrepresenting something. It's kind of like, intentionally lying to somebody is obviously the worst case scenario.
Deceit, yeah, level.
Exactly. Thank you, Dr. Farley. So let's look at one here. A North Carolina seller is aware of impending highway construction that will be built adjacent to their property and likely decrease their property value. So the seller's aware of it. The seller makes no mention of this to their broker, who makes no mention of this to the potential buyers. The broker is guilty of what? So I'm going to pause for a second. Think about this. I got to pick one of each. Right? Is it willful? Is it negligent? I'm going to say first things first. I'm going to say negligent. Should this broker have known? Yes, right? Because this is a material fact. Impending highway construction is a material fact, but I don't see the smoking gun here to say willful. So I'm leaning towards negligent. And then the easy one is, did this guy yap or did he keep his yapper shut? I see no mention. So I'm going to say a negligent omission. Let's go check it out. Boom. There you go. Brokers must disclose all material facts that we should reasonably be aware of. There's no smoking gun that shows us that the broker was willfully aware of it. And in this case, the broker kept his big yapper shut. So I'm going to say negligent omission.
Yeah. And here's where we see in real world practice agents saying, well, the seller didn't tell me and thinking that that's good enough. Yeah, you've got to discover some of these things, especially when it's something like an impending highway construction that is happening. A good example in the Triangle area is the 540 expansion, and so if you're meeting with a seller that's in the path of that expansion of that highway, whether the seller tells you anything or not, or knows anything or not, you have a duty to discover that and thereby disclose that to potential buyers. But yeah, this scenario you paint here is not uncommon at all.
Right. And that ties into the reasonable skill and care. We're expected to know more than the average citizen when it comes to these real estate matters. And there, don't get me wrong, there are situations where if a seller covers up damage, well, then you can't know that, right? You can't know everything, but impending highway construction, that's what's called a material fact. And that is something that must be disclosed to all interested parties there.
Yeah.
All right, sweet. So, probably my least favorite thing to talk about are stigmatized properties versus material facts, right? I don't mind the material facts so much. That's, of course,
Sorry.
defects. It's all right. Defects with the property. I thought it was mine for a sec. I was like, shoot. And so material facts is, of course, something's wrong with the property or impending highway construction, something along those lines. But stigmatized properties are not material facts. These are things that are maybe a reputation. Properties are branded by society as undesirable, such as the site of criminal activity or event, death of the occupant or owner, or an occupant or owner had AIDS or HIV. These are not material facts by North Carolina law. So it's a little bit of a slippery slope in terms of when should you say something and when should you not say something. I always say, listen, if you work for the buyer and you know that something happened at this property, unless it's a fair housing violation, then it's okay for you to share that information with your buyer. But if you're on the other side and you work for the seller, and this is something that comes up occasionally, is let's say there was a death in the family, someone died at the property. If you work for the seller, it's your job, unless the seller says otherwise, it's your job to keep that information confidential because it's not a material fact. So the thing you have to ask yourself is, who do I work for in this transaction? And that will oftentimes determine what I should disclose and what I should not disclose. Now, for example, if the resident had AIDS or HIV, that's protected under fair housing laws. So you never disclose that. That's a violation of somebody's rights. But if somebody died at the property or there was a crime at the property, that is usually not a material fact, and you do not have a duty as the seller's agent to disclose it. There is, of course, the one exception with criminal activity is if the property's been used to manufacture crystal meth, then that is a material fact, but most other criminal activity, not a material fact. You could disclose it to your buyer client if the buyer's your client, but if the seller's your client, you need to keep that information to yourself unless the seller tells you it's okay to disclose it.
Yeah, so this is where some students are surprised, right? They're like, what do you mean you don't have to tell me the house is haunted? Or that someone died in the home, or, a tragic event happened. Yeah, this is in North Carolina, not part of material facts, surprising to some.
Surprising to some, because in some states it is. That's oftentimes we'll have a student in class from another state and they say, well, in my state it is. Okay, I don't disagree with you, but in North Carolina, those are the laws.
Yeah.
And then same thing, not a material fact when it comes to the disclosure of a registered sex offender in the area. This is not a material fact. What I always tell people to do is consult with your broker in charge, follow your firm's policy. What I would personally recommend if I was your broker in charge is anytime this question is asked is to volunteer. Here's the volunteer that here is the registry. Here's the website where you can go to discover that information for yourself. Because if a sex offender lives in the neighborhood, that is not a material fact. You can voluntarily disclose it, or my personal opinion would be to say, here's the registry. Please visit that, discover for yourself. If that information is important to you, here's the way you can access that information.
Yeah, have those resources readily available to provide, but definitely don't get too and sometimes it's an impulse sometimes to answer some of these questions like that, but let them decide.
Yes. Especially as a new starting out agent, I was very often a yes agent and whatever you need agent. And there's sometimes when you just have to know that let me direct you. And the same thing when it comes to like criminal activity, you can recommend certain websites that maybe give statistics on that stuff. But it's not for me to say, well, this is a high crime neighborhood. This is not a high crime neighborhood. For one thing, I'm probably wrong. Whatever I think may be the case, that's an opinion. So let the resources do the talking in that instance, I say.
Yeah.
All right, so let's see, true or false. A provisional broker, I feel like they're all provisional today. They probably are. A provisional broker may disclose the presence of a registered sex offender in the neighborhood to their buyer client. And the answer is going to be yes. Yes, they can. They're not required to, especially if they work for the seller. Although it's not a material fact, we are allowed to disclose this information to their client. Same thing if somebody died in the home. Can I legally disclose that to my buyer client? Yes, legally I can. But if I'm on the other side, if I'm over here on the seller side, I do not have to legally disclose that. Whereas if, let's say, there's a leaking roof or a malfunctioning heat pump or a malfunctioning dishwasher, those are mandatory disclosures. But the presence of a registered sex offender or death in the family or most criminal actions in a property, that is not a material fact.
Got it.
All right, so let's hit on some commonly seen prohibited acts, right? Don't make false promises. We are prohibited from making false promises likely to influence, persuade, or induce somebody into doing something. So, for instance, don't promise someone an apartment. This is where you can get in trouble being a yes person. I learned the hard way. Yeah. Tell them what they want to hear. Don't tell them whatever they want to hear. Don't promise something that you will not be able to deliver, right? Especially don't promise things that you can't control, like other people's money, other people's resources. So be careful there. Conflict of interest, right? Brokers must follow license law at all times when representing the broker's own interest and those of the public. So be careful. If in doubt, put your client's interest above yours, right? You don't want to use information you learned about this client to promote your own best interest. There's a term for that called self-dealing, which shows up probably later in this section. If not now, you can certainly find it in the Appendix A. Self-dealing is putting my best interest ahead of the client's. Improper brokerage commission. Now, this is one I mentioned a little while ago. It's actually a misdemeanor, right? It's a misdemeanor, right? If you pay an unlicensed person. So a great example, a friend of mine used to tell this story. He lived in a community, had an HOA president, and that he was not the HOA president, but he had a friendly relationship with the HOA president. We'll call the HOA president Karen. All right, no pun intended there. And Karen was referring buyers to my friend, right? She referred 2 buyers to my friend. He said, geez, thanks, Karen. I really appreciate that. And he helped them and they bought homes. And then one day she referred a seller client to my friend and he listed the property and sold it. And then Karen started being unfriendly to my friend. She started kind of giving him the cold shoulder. One day at the swimming pool or the tennis courts or something, he said, Karen, what's going on? Hadn't talked to you in a while. And she said, when are you going to, take care of me the way I've taken care of you? When are you going to, do a little something for me there, pal? When am I going to get my, my referral? And he said, well, Karen, gosh, I would sure love to be able to compensate you for those referrals. However, North Carolina license law does not allow it. He says, Karen, as soon as you obtain your North Carolina broker's license and have it on active and current status, well, shoot, then I can pay you referral fees, not directly to you, unless you're independent, unless you're a sole proprietor. I can pay those referral fees to your firm, and absolutely, I'll be glad to pay you for those referrals. But meanwhile, he's not allowed to do so, right? Brokers are prohibited from paying an unlicensed person for acts which require a real estate license. So no referral fees, no finder's fees, no commissions. None of that is allowed, right, for referring. Now, the one exception I would point out here where you can share compensation with an unlicensed person is what I call a party to the transaction. And some real estate brokers go, shh, don't talk about that. But what that means is, as a buyer agent, I could share a percentage of my commission with the buyer, as long as it's disclosed to the buyer's lender and we have the lender's blessing. Because look, it's ultimately the buyer's money, right? If I'm the seller's agent, I could share a portion of my commission with the seller, because it's ultimately partially the seller's money. But if it's there, the person is not a party to the transaction and they do not have an active broker's license in North Carolina, then I am not allowed to pay them a referral fee or any what I call transaction-based compensation. Anything that you'd like to add to that, Jason, or feeling good about it?
Yeah, I mean, this takes us back to the beginning of our series when we're talking about what a license, who needs a license, and again, it keeps coming back to that definition of if you're conducting real estate transactions for compensation, that's where you need the license. And so, again, this unlicensed person can't pay them, can't do anything with them other than say, thank you.
Thank you. Give them a hug, right?
Yep.
That's fine. But yeah, no transaction-based compensation unless you have a broker's license. Exactly right.
Now, because we do have a broker's license, I guess that means we're expected to be competent.
Yeah, exactly. Worthy and competent. I'm always like, some of these laws, I'm like, it's kind of obvious, isn't it? But yeah, right. So be worthy and competent. And so a good example would be, and I know some agents like this, right? Especially down east, we got some Easterners. I'm not picking on the Easterners down here, but we've got some agents who might be tempted. Let's say I've got an old computer and I've got a contract, offer to purchase contract from 2015. And someone goes, hey, Rob, will you help me buy a property on Topsail Island? Sure. I've got a contract right here. And I open it up and I go, let's just use this one. Right. And the problem is a lot's changed from 2015 to 2022. So if I'm using an outdated contract form, there's a great chance we're not going to get our offer accepted. The listing agent's going to take one look at it and say, what? This isn't even the correct contract form. So I probably costed my client the opportunity to purchase the property they really wanted. So that would be an example of unworthy, incompetent actions from a real estate broker. Something I try to avoid. And something else you want to avoid: improper, fraudulent, or dishonest dealing, right? Anything that is considered improper behavior, fraudulent behavior, or dishonest dealing with a client. Somewhat I call first grade, mentality here. Don't do anything inappropriate. Don't lie to people. Don't do anything to abuse their trusts.
Pretty simple. Yeah.
Pretty simple. I like to think so. All right. So let's review real quick. True or false? Speaking of unlicensed people, and this comes up a lot, an apartment company may offer the following promotion to tenants currently under a lease contract: refer a friend and receive 1 month's free rent. So think about that a sec. Is that something they can do? I'm going to say no, it's not, right? And everyone, well, not everyone, but most people, when they see that, go, well, why do they do it all the time? And I go, well, they probably don't do that. They probably offer something similar, which we'll look at in a sec, because if they are offering this, they are breaking the law, not only North Carolina license law, but it is a misdemeanor in North Carolina to pay referral fees to an unlicensed person unless they are a party to the transaction. So if I live over at Gorman Crossings Apartments in Raleigh and I refer someone to the community there, Gorman Crossings cannot pay me a fee. They can't pay, well, they could pay me because I'm a broker, but an unlicensed person cannot earn that fee, not even 1 month's free rent. So you know who they could pay. Let's take a look and see here. The same apartment company could offer, true or false, 1 month's free rent to the new tenant. Yes, they can. Yes, they can, because that tenant is a party to the transaction. So, what you've probably seen these apartment communities advertise is lease now and get 1 month's free rent. Okay, great. They can do that, or 2 months free rent, because it's your money. Your money, they're sharing your money with you. You're a party to the transaction. But if someone is referring you and that someone is unlicensed, then unfortunately that's not going to work.
Key element there. So in the previous question, the folks receiving the benefit are no longer a party to the transaction. They're already there. They're already under a lease. They're already in there, and they're referring folks, and therefore they are no longer a party to that transaction. And let's assume that all of those tenants mentioned are not licensed brokers.
Correct. Only if they were a licensed broker could they receive that fee.
Yeah.
Absolutely right.
As opposed to your second scenario, there is a party to the transaction here that, again, we can compensate.
That's right. We can share. And a lot of brokers are like, shh, don't tell them. That actually happened to me one time. I heard some guys talking about it. A really young 20-something broker was talking to his buddy, and we were all three buddies. And he was like, yeah, man, the buddy said, I'll buy a house from you if you give me half the commission. And the broker said, I can't do that. I said, I was sending a fax nearby. And it's how you can tell it was a beach company, because we still use fax machines. And I said, actually, you can, but you may not want to. So I usually do, by the way, because I'm nice like that. All right, we'll do a couple more reviews, and then we'll take a break for we'll wrap up session 3 here. Residential and HOA disclosure forms. So this probably feels a little left field. You're like, what? But you know the answer to this if you're watching this video. And this same question will come up in post-licensing. Can a broker complete the residential and HOA disclosure form on behalf of their seller? What do you think? No, you may not. No, but we are expected to provide the form and assist them, but you never, ever, ever want to be fit, especially once you've actually seen this form and you know how detailed it is. It makes me feel a little dizzy just thinking about this form. And so I'm definitely not filling this out for somebody else.
Yeah, this is what I call the seller's homework. I leave it for them for their homework, and I, give them the instructions, but yeah, definitely not the form or any seller-related disclosure forms that you'll be completing as their broker. That is for them to do. Very important. Right.
Very important. Now, speaking of, a little while ago, this one we did touch on, the North Carolina Real Estate Commission. We said there are certain things that they draft, their attorneys draft, and they provide for us to use, but there are most things they don't. Does the Real Estate Commission draft contracts for agents' use? And the answer is no, they do not. You can get contracts if you're a member of the North Carolina Association of Realtors. They draft them for their members' use, hence the word members' use. And any other contract drafted by an attorney may be used, providing it meets I think it's 20 different NCREC approval guidelines criteria. But the North Carolina Real Estate Commission does not draft buyer agency agreements, listing agreements. They do not draft sales contracts. They draft the working real estate agents. They draft the residential property disclosure. They draft the mineral oil and gas disclosure, which are all consumer protection. So do not call the Real Estate Commission once you pass your exam and say, hey, how do I get an offer to purchase? Right? It's one of those things they prefer you call the Association of Realtors. They would be glad to talk to you about that.
Yeah, and a common question that comes up about the drafting of contracts in relation to this too, but whenever a question or an answer or choice says the agent, the broker drafted. So if you see those two words side by side, especially broker drafted, something's wrong, right? That is not the right answer, because we as brokers cannot draft documents, legal documents. No way.
So, no way. We do not draft.
Cannot draft. And then another related question is, do we have to use those forms drafted by, in this case, the Association of Realtors? Well, one, you can't unless you are a member. Like Rob mentioned, you're a member of the Realtors Association. One of your benefits is that you get pre-drafted forms and contracts and things like that. But if a question asks you, must you use those pre-printed forms, then the answer is no, as long as you didn't draft it, Mr. or Mrs. Broker. But yeah, the forms collection, the contracts that we have the privilege of using as a realtor aren't required. We don't have to use those specific forms, but we also can't draft our own. Rob, can a seller draft their own, or buyer, I should say, draft their own offer to purchase?
I would not recommend it, but technically they could. They can draft it's what I tell my students, I say that I call it the This America provision.
Sure, I
This
can buy a
America.
book.
This America. And no one's going to say you can't write your own, at least yet. They don't say you can't write your own contract. I would not recommend it. I'd say if you want an addendum or a contract to be upheld and enforceable in a court of law, you really want an attorney to draft it. So I always say leave the drafting to attorneys and race car drivers, right? Do not draft the document yourself. And I do not recommend that a buyer or seller do it. I recommend that they consult an attorney and have an attorney draft that document, because sometimes you need that. Sometimes you need an attorney to draft a unique document, a unique addendum. And when I worked for a developer years and years ago, we didn't use realtor forms. We had our own attorney drafted sales contracts, and that's what we used. So it's 100% right to say you don't have to use the NCAR contracts as long as they're attorney drafted and meet the necessary criteria of the real estate commission. You can use it.
Yeah. Well, great point. Let's end there. Let's take another break and we'll pick up session 4. Let's see, what are we covering in session 4? Let's see, I'm looking ahead at some additional prohibited actions, such as the practice of law. You guys will come out of this course and head into the state licensing exam to earn a broker's license, not a lawyers. What was the official term for lawyers?
Bar exam. You're
a bar exam.
So yeah, you don't want none of the bar exam. Trust me on that. I've heard.
Yeah, let's start with real estate anyway. And so we're going to talk about or remind folks that we are not lawyers and therefore we cannot practice law. And we'll go into more details about that. We'll also touch more on advertising do's and don'ts as a broker under licensing law. Again, advertising. Then we're going to touch on some topics like confidentiality of offers and what specifically does that mean. Retention of records. Real Estate Commission requires us as brokers to retain records for a certain amount of time. Another number coming at you that you'll need to remember. More about disclosures as well, disclosures of compensation specifically. So that and more in session 4. I hope you'll join us back again for the next segment in our series. Again, breaking down licensing law and rules comments, portion of Appendix A, which is again a big portion of the state content that you'll be tested on, both in the course and in the state licensing exam. Rob, thank you again, buddy. Let's head over to the bar for a beer and have one before we start segment 4. What do you say?
Perfect.
I'll meet you there. Thanks again. We'll see you soon.
Right. See ya.